Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Welcome back to the Business Owners Council, Legal Issues from Growth to Exit. My name is Kevin Rosenquist, and in each episode, we sit down with Kevin Brick, founder of Brick Business Law and trusted advisor to Florida companies, to break down the strategies that business owners need to grow, protect, and maximize the value of their business. Kevin will walk us through the lawsuits that can derail deals, the risks owners often overlook, and the steps you can take now to protect both your company and your legacy before and after an exit. Kevin, welcome back.
Thanks for having me, Kevin.
So yeah, we're going to talk about the lawsuits that kill legacies. What did you say in your career are the most common lawsuits that sort of blindside owners before a sale?
Yeah, I mean, it's probably just the same ones that you would see in a business normally when it's operating. So the big kind of categories I would say are like employment lawsuits, like wrongful termination, wage and hour discrimination, and then partner disputes, like internal partner disputes. And then I would say the last one is probably just like general run-of-the-mill breach of contracts between a business and like their key vendors or customers that are complaining about something.
So you see often that there might be some sort of an employment issue, employment lawsuit in process that was not disclosed.
No, more along the lines of like as a business is nearing a sale or after they've listed it, something then kind of blows up on them that
Uh,
hadn't existed before, and then that sort of derails the process of getting it to market or getting it through a sale.
okay, that makes sense. All right, I got
Yeah,
you.
yeah.
How does a pending or threatened lawsuit affect a deal typically?
I mean, basically, it just, if you think about it from the buyer side, it just adds risk to the deal. So, buyers usually react in one of maybe three different ways. I would say, like, one is they might really want to delay the deal or walk away from it. They want to wait and see how it works out. Another way they might handle that is they would just lower the value, their purchase price to deal with the risk. And then I'd say the last thing that they might do is try to like ask for the seller to give more concessions, like indemnity or hold back money in escrow until that's resolved if it can't be resolved prior to a sale. So essentially, it's bad news for the seller. In some way, they're going to have to give some concession up, typically to the buyer.
Yeah. Yeah, what is it just I don't know, it seems like one of those things that like you should know something about before, but these things just tend to come up between like the business going on sale and a buyer looking to buy it. It seems like that's a short window.
Yeah, I mean, if you think about kind of the process of selling a company, there's a time where it's listed, and then there's this like due diligence period, and then there's a closing. So as businesses are running in the interim, they're operating and all the things that are happening that typically happen, and then you know, as it often does, the thing that can't go wrong goes wrong right in the
Mhm.
middle of that time period. But sometimes too, like the process of getting ready to sell a business, that also may prompt things that come up. For instance, if if a buyer is doing due diligence and they start asking questions as they normally do about corporate records and different things, then that might spur, partners to have a disagreement over what the prior, agreements in the company said, and now it's been brought into the light, right, because of the
Mhm.
sale process.
Yeah, the sale kind of ignited this stuff, right?
Yep.
Yeah, yeah, that makes sense. So there's a term in your world called successor liability. Can you explain what that is and why it's important?
Yeah, I mean, basically, what it means is that as the successor of the company, meaning the buyer who has closed on it and taking over, they are going to be liable, or they could be liable, in certain deal structures, for the past claims or debts or problems that were created before the sale. So essentially, you think about a buyer who's been in a business for 6 months or a year, and all of a sudden, they get a claim from a former employee, or they haven't paid their taxes, and they get a notice, and it's from something that happened before they even bought the business. So there's this concept where the successor can have liability, and that just sort of, that idea brings out, the thought that you have to have a deal team that informs the buyer and seller, on each side about the structure and what the risks are. And so there's no problem with the fact that there's successor liability, so long as the parties understand, what are the terms, what are the risks they're accounting for, and being able to handle those, in the pricing of the deal and the terms and all those kind of things.
If things come up like that, and that in your example, you said like 6 months down the road into the new owner having the business, do they have any recourse against the seller?
Well, it really depends on how the deal is structured, right? So, we're kind of talking about maybe a bunch of different concepts here, but there's representations and warranties of the seller, where they represent that certain things are as they are, and then there's indemnity provisions that basically establish what the seller would be responsible for after the transaction, and then there's things that maybe the buyer just assumes the risk of, right? They're taking over an entity, and so those things all come back to what actually are the part of the negotiated deal. And as you can imagine, a lot of litigation and lawsuits come out of those things. What should have been covered, what wasn't, what was represented, and what wasn't. And so those are part of the risks of closing a deal, and that's also part of why you really need to have a great deal team that puts and structures the deal in a way that makes it make sense for everybody.
What would you say is the most overlooked area of litigation risk, especially in maybe closely held or family businesses?
Well, family businesses in particular, we talked a little bit earlier about how, like, sometimes during due diligence, there will be original incorporation documents that are brought up, and things that maybe, especially with families, like they don't write a lot of things down. They have all these oral agreements. When grandpa retires, you said I'd take over 20% of the company, and that never happened, and now we're selling it. And so I'd say, like, the most overlooked thing, well, and maybe the most difficult for family companies, is like these kind of, you said 20 years ago, and then that never happened. And with families, it's even more complicated, because they're like, well, you never loved me. It's like you got all these kind of, like, deep seated things that go on, and that kind of come out as a result of maybe not documenting things well in the company, because it's brother and sister working together, and not like a formalized entity.
Yeah, I laughed when you said that, and I don't mean to seem callous, but I mean that just came out of no. I was like, whoa, yeah, I guess like that can bring up some serious emotional baggage that might be hanging on in different settings, and I suppose you've seen some pretty interesting uh, discussions, shall we say?
Uh, yeah, I mean, when you get into the family-owned businesses, it is, it's half about the business and it's half about the relationships and emotions, or maybe it's 10% and 90. I don't know, but it does make it a lot more complicated when you're dealing with kind of the family founders and multi-generation businesses, and those relationships can get very complicated.
So it's like reality Succession.
Right,
Yeah.
exactly.
You mentioned the employment related lawsuits earlier, and we kind of talked about it a little bit. How do those show up in an exit deal?
When a business transitions, a lot of times, there are key employees that kind of, they have to stay on to ensure that the value transitions. Like, they know a lot about the business, maybe they're the leadership team. So certainly, if you get a lawsuit involving one of those key employees, that's going to be a big deal. But then, there's kind of, even with a minor employee, you think about, if they file a claim, and they're claiming that maybe there is a hostile work environment, or something that brings certain negative issues to light, and those are things that come up just prior to a deal being closed, or during the due diligence, or they get discovered during the due diligence. Those employment related claims obviously can make a big difference in terms of the enthusiasm of the buyer to follow through with it.
Absolutely, yeah. I would imagine no one wants to hear that, of any issues, but something about employment issues, employee satisfaction, happiness. Like, are there problems there? That's a whole ball of wax there that no one wants to get involved with.
Yeah, I mean, you have to think, like, for the buyer, like, these are going to be their employees. So
Right.
if there's problems evident prior to the transaction, certainly that's going to give them pause, right?
Absolutely, yeah. And who knows? New ownership could sort of rally the troops, if you will, and make people excited again, but maybe not. And maybe that's short lived. Who knows how bad the damage is?
All right.
Yeah, that makes sense. All right, so we're talking about these risks. What can owners do now to help mitigate any sort of these litigation risks?
So I would say the general approach, if you are years out or even months out from thinking that you want to sell, our approach really is the strategy is you want to identify and then resolve any sort of lingering legal risks or issues that exist before taking it to market. So um, you have to understand that the buyer is going to do a sophisticated buyer especially is going to do a lot of due diligence on the business to make sure they're not taking on the risks of the business. And so if they ask to see, and they will ask to see your corporate documents, your employment documents, your contracts, your leases, all these things, um, if you can get out ahead of those things as a seller and make sure they're reviewed, problems identified, that they're updated appropriately, that things are put in place that maybe don't exist. You go through this sort of pre due diligence process of making the business really a well oiled machine on the legal side. Those are some things that that sellers can do to mitigate their risk before going to market.
Now, from the other side, from the buyer's end, how can they shift litigation risk back on the sellers during negotiations?
Yeah, I mean, you see this obviously with very sophisticated buyers is that they're looking really to the deal terms to limit their exposure as much as possible. So they're looking at a couple of things we've talked about already: indemnity clauses, making sure the seller indemnifies them for risks that happen. They look at broad, what's called representations and warranties of the seller to make sure that essentially what they're saying is you seller are representing to us that there are no problems with the finances. There's no problems with, all the taxes have been paid, all the licenses are up to date. There's no employment issues. You're not aware of ABC problems. So they'll be very thorough in those processes. And so, there's this process of give and take between sophisticated buyers and sellers. And so it's really important to understand as a business owner, as a seller, like understanding what is sort of standard, in those protections, and then what's really like overreach, like making the deal oppressive, right? Versus
Mhm.
making it sort of fair and even handed. And so there are certainly risks that buyers have not knowing the history of the company. And so there are obviously some things that are going to be expected that are represented. But especially a lot of like big private equity groups and others, they may tend to overreach and cause sellers to have to cover a little more than they should. So that's why it's good to have that kind of sophisticated deal team in place before going to market and then during the negotiation to make sure that those buyers aren't putting too much on the sellers in terms of covering risks.
You work with buyers and sellers?
We do. I mean, typically, our clients, particularly, are the businesses that oftentimes are being acquired. But sometimes we do work with companies that, as part of their strategy of growing, they're acquiring other companies. So we are on the buyer side sometimes as well.
Do you kind of try to help coach buyers as far as how important certain risks are? Like if a buyer's a bit scared of something that they see, do you try to temper that a little bit, try to calm them down and sort of, I don't know, walk them through the scenario so that they're not so freaked out by things that maybe aren't a huge deal?
Yeah, I mean, it's funny when when you think about the psyche of different types of buyers. So there's strategic buyers who are looking to grow their existing business, maybe by acquiring competitors or businesses that will complement them. And they're in the industry, they might know what they want. And then there's maybe like the buyer who they're making their first business acquisition ever. It's going to be kind of to them like a new thing. And of course, they know maybe less than the strategic buyer. And then you have very sophisticated buyers. I talked about private equity, others who, they've got their whole deal team in place. They've acquired a dozen companies that look like this. They know all the KPIs and different things that they want before they buy a business. So, we're working with sort of that small to medium sized company, and there are deal terms that bring comfort to buyers and sellers, knowing that certain risks can be mitigated and addressed. And that's sort of like you hear kind of the art of doing it is
Mhm.
basically bringing the parties together in a way that they can accomplish their goals. And usually the goal is getting the deal done and doing it without taking on taking on too much risk or pricing it correctly. And so those conversations, as they're walking through that process, are very important.
What are earnout provisions and how can they create litigation risk after a sale?
Yeah, so an earnout is usually something that a buyer wants, right? It mitigates some of the risk for the buyer, and they're telling the seller, we're going to hold back some percentage of the purchase price, in essence, and we're going to pay that to you so long as after the transaction, the business accomplishes these certain goals. Like, let's say it continues to grow at 5%, or revenue hits this. Then if it does, then we'll pay you, that additional 5%, 20%, whatever that is. And so that does create some unique risks to the seller, because they're not in control of the business anymore, right? So after they turn it over, maybe the buyer doesn't run it the way that the seller did, or maybe they change their strategy, or maybe they fire people or do different things, and so really there's a they don't have much control generally over whether or not that revenue is met or those goals are met. Sometimes, in a poorly constructed deal, some of those targets might not be well articulated, so it's hard to tell. So you do run into all those problems. Sometimes it can be mitigated to some extent if you've got a seller who stays on board. Like maybe they're going to run the sales department, or they're going to do something after the transaction. And typically in what they call an earnout, like there is some sort of participation happening with the seller after the deal. But it does, it adds a layer of complexity and a layer of risk for that seller, having to, what they say, earn it, after the deal's done.
Does insurance play a role? I mean, I feel like you can insure anything. So like, do you insure, are there aspects of this that where insurance gets involved?
There are, I mean, there's like representations and warranties coverage for post-transaction liabilities, and obviously there's limits on those things. Like you can't hide something, and then if later it comes out, then you're covered by insurance. So there's limitations, but there are products that exist to cover those things. Um, Maybe not in every situation, but certainly it's something to discuss as one way to limit risk. And part of the discussion and negotiation also is like, who's going to pay for those policies. And so that's something that should be brought to the table during the transaction, is to, how, if and how insurance can be part of this deal.
If litigation does arise after a sale, what's the best way for an owner to protect their family, their legacy, their business?
Yeah, I mean, so a lot of lawsuits obviously do come post-transaction, whether they're related to representations and warranties that, there was somebody was misled, or there's an allegation of that. A couple ways the deal documents address a lot of those things, so that's one way to try to avoid or mitigate those risks. Um, Specific things you might want to do or have, like arbitration and mediation provisions in there, so that you can try to avoid lengthy litigation, and try to have those things dealt with quickly. And then also, a piece of it too is asset protection. Buyers and sellers should put in place asset protection strategies, so that if something goes sideways, which happens a lot, that they can make sure that some or all of their assets are protected from liability if the terrible thing comes, and they're somewhat insulated against that.
All right. Well, Kevin, great advice as always. That wraps up this episode of the Business Owners Council with Kevin Brick. Selling your business should be about celebration, not a courtroom battle. If you'd like to learn more about how Kevin and his team at Brick Business Law help business owners shield their companies from costly disputes and safeguard their legacies, visit brickbusinesslaw.com. And as always, don't forget to subscribe and leave us a review. We very much appreciate it. Kevin, always great chatting with you. Thanks so much for your time.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.